Okay, so in today's session, we will have a glance of legal notice, like everything about it, how a legal notice is drafted, and what should be your approach to draft a legal notice once a problem comes to you, or once a client comes to you with his problem, how you should approach. Okay, so to start with introduction, this is Sanjeev Singh, and currently I am a CS professional. I have cleared CS executive this year with All India rank 11th. So without wasting much time, let's get into it. And I will share a PPT with you. I will share my screen. That PPT will be shared to you in WhatsApp group and just after this meeting. So let me share and start it. Is my screen visible to everyone?
Sir,
Yes, it is visible.
no, sir.
Okay, I hope so. My screen is visible to everyone. So we start with legal notice. First of all, let me explain in a very plain language what is legal notice. Okay, legal notice is just a formal communication between sender and a receiver. It is not like something very big or something very extraordinary. It is just an ordinary communication to clear the misunderstanding between sender and the receiver. It can be called as outside court settlement. Okay, because by sending legal notice to opposite party, we we think that problem will be sorted out in mm, just outside the court, because courts takes a lot of time. Okay, it takes times and money, of course, and it is just a waste of your precious time. So to settle disputes outside the court, generally legal notice is preferred. Okay, to start with introduction, it is just a formal written communication between the parties. See, first of all, we must understand that when a legal notice is sent, in 90% of the cases, we send legal notice to opposite party in civil suits, in civil matters like recovery of money, bounces of check, and so on. So since it is a civil matter, and in civil matter, everything should be in written. Okay, if you go to court and file a suit before the court, then court will not entertain your oral arguments in civil suits. In civil suits, everything must be drafted and properly, like well written, well documented. And that's the reason the legal notice should be written. It should not be oral or something else, but it should be written. Okay. And through legal notice, sender notifies the recipient about his intention of undertaking legal proceeding against the letter. So through legal notice, the sender, who is the person, notifies the receiver that why the sender is sending a legal notice. What is the motive behind sending the legal notice to the receiver? Okay. Next is legal notice helps in making the receiving party aware of the grievances of the sender. See, suppose there is two person, Mr. A and Mr. B, and Mr. A is the employer and Mr. B is the employee. And due to some reason, Mr. B has breached the employment contract and left the job. And Mr. A, on the account of breach of employment contract, refused to pay the monthly salary for which B has worked. And so, what are the options available to B? B can either go to courts for his salary as a matter of right, or B can send a legal notice to A, who is the employer, to pay him the salary. Uh, since going to court is a hefty task, it will consume so much time and money. It is always easy and it is like comfortable to send a legal notice to settle the dispute outside the court. B will draft a legal notice. He can either draft by himself or he can go to a lawyer or contact a lawyer and sent a legal notice to A for the recovery of his salary. Uh, this is the basic form. This is the basic like idea of legal notice to recover anything or to settle the dispute outside the court. So it is necessary for a person to stick to the format of the legal notice. See, there is nowhere in the law a format for the legal notice has been prescribed. It is nowhere prescribed. I hope so, because still, yet I did not come with any sort of format by which a legal notice would be drafted. Personally, I have drafted several legal notices, but I have not followed any sort of like format. It depends upon the circumstances. It depends upon to whom we are sending the legal notice. The format depends upon the each circumstances of the case. It can like it works as a last warning to the receiver. Suppose Mr. A and Mr. B, take the example of employment contract. Mr. B has sent a legal notice to Mr. A by stating in the legal notice that if Mr. A did not act upon this legal notice within the certain limited time, then Mr. B will file a suit against Mr. A. And of course, it is tool to save time and cost of litigation, as it opens the door for the parties to settle the matter through negotiation, mediation, and so on. Like it can be called as ADR, or we can put legal notice under ADR. I think ADR falls under section 80 of CPC, if I am not wrong. The disputes can be settled and just by negotiating or mediating among themselves. Next is situations where legal notices can be used. See, there is nowhere described that in what situation legal notice should be used. You can use in n number of situations, but some like highlight situations are provided in this slide. In consumer forum, of course, if a faulty product or service has been served to you, then you can file a legal notice against that person. And if that person did not act as per your convenience or as per your demand, then you can file a suit in consumer forum as well. Dispute related to property such as partition. See, if you would have gone through the Hindu law, then partition can be merely done by writing a notice or writing just on a piece of paper that you want partition. That falls under the definition of legal notice. Loan defaulters, of course, loan defaulters will be sent a legal notice. And most important is cases under NI Act. If you read NI Act, then in NI Act, legal notices are much more used as compared to any act. I personally feel this because uh, the whole world is like based upon business, and all the transactions of the businesses are mostly governed through the NI Act, like dishonor of check, banking, and all. Mostly it is governed through NI Act. So in case of dishonor of check, the notice will be sent to the payer by the bank within 15 days, and the payer will have to pay the amount to payee after 15 days of receiving the notice. And if it does not do so, then it is a criminal offense in NI Act. See here, one thing you must notice that NI Act is a civil act, we can say, but in civil law also there is a criminal offense. Like dishonor of check constitutes a criminal offense. This has been dealt by Supreme Court in various cases. Next is in money recovery case. Suppose take an example. There is two person, Mr. X and Mr. Y. Mr. X has lent some money to Mr. Y and promised that Mr. Y will pay it to Mr. X just after 2 months. And after the expiration of 2 months, Mr. Y did not pay the money to Mr. X. Then Mr. Y will come up with a legal notice to Mr. X stating that Mr. X, please pay the amount or else I will file a suit against you in court of law. Employee and employer of a company. Of course, employee and employer, just I had explained an example. So please make sure that while you are drafting a legal notice, use soft languages. Don't be so rude towards other person. Don't use harsh languages, and never threatens the opposite party. Use language like you are requesting them and not threatening them. Be polite with your drafting. Next is content of legal notice. Mm, Content simply means what are the things which should be included in legal notice. See, of course, a legal notice is drafted by anyone can draft the legal notice, whether it is an advocate or the person himself. But it is always advisable to contact your advocate once a problem comes to you, because they will draft a legal notice in such a way that would no flaws in your there would be no flaws in your notice. In India, it is presumed that law is like known to everyone, but it is not true. And even in court of law, mistake of law is not considered, and it will constitutes an offense. But in practical scenario, it is not at all true. Nobody literally knows the law except for the lawyers. And here, I hope so, all the students are law students. So you need not go and consult a lawyer. You can draft a legal notice by yourself as well. But try contacting your friends, because they will give some better insights, like unity is a strength, as you have heard. So we can take an example like a person X took goods on credit from Y on 4th May 2020 during the ordinary course of business on the pretext of paying for it after 3 months. See, there is a person X who took goods on credit from Y. Okay, and in ordinary course of business, the payment is made after 3 months. Now, if X fails to make the payment, goods after 3 months, Y can send simply. If X fails to make the payment, Y can send legal notice to Mr. X demanding the payment of goods. Title of legal notice. See, title is very, very important. Don't make title so lengthy and so rubbish that the opposite party, after reading the title itself, did not understand anything. Title should be catchy, it should be informative, it should be emphasized and short. It should not be so elongated. By reading the title itself, the opposite party shall come to a conclusion that what for the legal notice is, what would be the content of legal notice, because it would like clear all his doubts. Title should be exact. So for this problem, like a person X took goods on credit from Mr. Y, a probable title can be notice for the recovery of money on account of credit sales of goods. Or you can say, or you can even put a title that notice for the recovery of money. That's all. No need to elongate, and title should not be much more bigger than 2 lines. It is a general practice. If you come and if you draft a real legal notice, or if you read a real legal notice, then you could not find title more than 2 lines. Next is matters and facts. See, matters and facts are the heart and soul of legal notice. Uh, it is very important to write only the things which has been said to you by your clients. Never add anything by yourself, because ultimately at the end it will go against you. See, while I was reading this legal drafting, or you can say legal notice, then I was thinking that I could draft legal notice against anyone stating anything, but practically it is not possible. If you do so, then it will go against you and you only. So try to avoid it, and always make sure to like whatever the contents you have mentioned, make sure that right above the contents that on behalf of my client, or my client has stated this, because it is not your notice, it is your client notice. You are not the person who is a party to this legal notice. Your client is the person. He might be the aggrieved person or whatsoever. So if you look at this example, a person X took goods on credit, then the probable matters of facts would be like Mr. Y is writing to Mr. X that you bought goods on credit from my client on May 1st, 2020. Next, that you promised to make the payment to my client within 3 months. and next that you fail to pay the amount till August 1, 2020. Your body should not be like too much elongated. It should be exact, like after reading the matters and facts, the opposite party comes to a conclusion that what the aggrieved person wants to convey. That's all. You should not like add so many annexures and all. Mm, Probably try to avoid adding annexures. Few days ago, one of my friend has received a legal notice from a company. Like legal notice was of 64 page. I was just shocked after reading the that particular notice, and I had a closer view of that notice, and I found that the main matters and facts was only on 2 pages, and rest of the 62 pages was fit for nothing. Like they have added so many annexures and all, which was not at all necessary. Try to make it short and accurate. Do not add whatsoever you want to add. Please avoid this. Next is sender demands and requirements. Suppose there are two persons, Mr. A and Mr. B. Um, we can take the reference of the example. Mr. A is the employer and Mr. B is the employee. And Mr. A did not pay the amount to Mr. B for working for S company. So Mr. B will write a legal notice to Mr. A asking, please make sure to mention the demands and requirements of your client. Like Mr. B will mention that what he demands from Mr. A. Okay, demands should be mentioned and requirements should be mentioned. Earlier, I was reading that particular legal notice of 64 pages. Mm, Let me explain you the story first. Uh, See, the person who has received the legal notice was a employee of that company, and he left the company due to some personal issues, and he informed the his manager, but his manager did not forward that message to his superior manager, and the company has written a legal notice to the person stating that due to your unavailability or due to leaving of the company without the notice period, this company has suffered a loss, and you are asked to pay rupees 50 lakh to compensate the company. I was really shocked after seeing the notice, like compensation of 50 lakh was demanded by the company. So, while mentioning the demand, please make sure that your demand should be rational. It should make some sense. 50 lakh does not make any sense just for an employee who is getting 30,000 or 40,000 salary. He could have asked for 10,000, 15,000. That's okay, but 50 lakh does not make any sense. In your demands, make sure that it is rational. There should be rational nexus between the employer or employee or whatsoever. And please use your prudent mind. Don't just overlap or elongate and write as much amount as you want to get just by threatening the opposite party, and just by thinking that the opposite party will not take any action. Never do this. Be rational. Next is result and consequences. See, you have written a legal notice to the opposite person mentioning that my client is suffering from this. We want uh, this, or the demand of my client is this. So if the demand is not fulfilled, then what would be the result? In most of the cases, we go for a suit after non-compliance of opposite party with a legal notice. And please make sure to give the opposite party a reasonable time frame. Time frame should not be less than 15 days. In practical scenario, minimum 15 days time frame is given. Do not write a legal notice today and ask your client to pay the amount tomorrow or to settle the dispute tomorrow itself, because practically it is not possible and it is not even accepted in court of law. Court will ask you that whether you have given the reasonable time to your client or to opposite person or not. Reasonability and prudential mind application is very important. So from the above problem we can write we can draft like this. that in the event of failing to do so, my client has given me a clear instruction. See, my client has given me a clear instruction, not me. Earlier, I already mentioned that everything you must write, it should be on behalf of your client and not you. So you will write, my client has given me the clear instruction to file a suit for recovery along with civil and criminal suits in the competent court. And in such event, you will be fully responsible for all the expenses, costs, risk, and whatsoever. Sorry. So here it is mentioned that in case of failing to the compliance of the notice, my client will initiate a suit against you, and you will be responsible for paying all the expenses and cost of litigation. This is the resultant consequences of non-compliance of your legal notice. This is a legal notice sample. You can go through it. And this legal notice is a consumer dispute legal notice. And the scenario is like when a person is provided with deficit good and service, can file a legal notice against the concerned person. Suppose you have ordered anything from Flipkart. Take it example as a laptop. You have ordered from Flipkart and you got a broken laptop. Because it served as a basic minimum period which should be given to the opposite party to settle the disputes. So this legal notice start with two. You mention here two, uh, Mr. or MS who has served the service to you, or who is the manager. Am I clear to everyone? Is my voice clear?
Yes, it is clear.
Okay. Next is significant points to be kept in mind. Uh, See, there are few points which is nowhere mentioned, but it should be kept in mind while drafting the legal notice. See, first, it will take time like registered post or courier in India. It takes around 5 to 7 working days. So please make sure to at least give time to courier for at least 7 days. Take 1 week as the delivery of legal notice. Next is English is a generally accepted language of sending a legal notice in India. Uh, Still, it is nowhere mentioned that what should be the language of legal notice, but make sure to draft it in English because it is generally accepted. And since India is a diverse country and we are having so many languages, but English is generally accepted to all the states. You can even draft in your local language or Hindi as well. There is no bar on it. And no document or annexures are required, as I have already mentioned that no annexures are required. Annexures are mostly sent to the courts while drafting the plaint for the suit, because court is the ultimate uh, decision makers and they need proofs to come to a conclusion. But in legal notice, there need not to be any annexures or attachments is mandatory. Next is it is not mandatory to reply a legal notice. Suppose a legal notice has been served to you, it is not at all mandatory to reply. But again, if you will not compliance with the terms and conditions, then the opposite party will file a suit against you. So it is always advisable to reply a legal notice in a way that particular notice demands. Please reply to every legal notice. Don't skip the legal notice. If it is unnecessary, you can skip it. But in general practice, legal notice is replied politely. Again, how a legal notice is served. See, you can find in CPC or CRPC the way of service of someone. Uh, in that way, you can serve a legal notice. But in case of SBI card versus uh, Rohit Jadhav, the Bombay High Court has accepted that even legal notice can be sent through WhatsApp, Telegram, email, or fax or whatsoever. And the court observed that in case of WhatsApp, blue ticks shall be considered as the delivery or uh, delivery of legal notice or service of legal notice. Here, I find one flaws because court should know that blue ticks are easy to off, and in today's scenario, most of the people make sure to off their blue ticks. So it should not be like blue ticks. If there is no blue ticks, then the service of notice has not been served. The court should rectify this in today's scenario. See, if the sender is aware of the recipient alternative address, suppose you are a sender and you are sending a legal notice to someone else. If you know the person's original address, then you can write original address, phone number, email, fax, or whatsoever. And if you know that the person is a working professional and he works at different places of the country, then you can write alternative address as well. It is necessary because it will reach to the concerned person on time. As I have already mentioned, there is no set or format of legal notice. It totally depends upon the circumstances. It differs from case to case, and it depends on the drafting skill and command of laws and language of advocates. To draft a legal notice, you should be knowing like maximum laws. If you do not know the laws, then you will not be able to add much legal points on legal notice. And if you are drafting a legal notice for a breach of contract, suppose there is a contract between Mr. A and Mr. B. Mr. A is an employer, Mr. B is an employee, and Mr. B has breached a contract. Mr. A is sending a legal notice to Mr. B against the breach of contract. Then Mr. A must mention the clause of contract which is breached by Mr. B. The breached clause must be specifically notified or specifically highlighted. The mode of dispatch can be either electronic or physical. In this era of digitalization, even the courts summons are being sent on WhatsApp or email. I have seen that the High Court summons are being served through email and WhatsApp. And talking about fee of legal notice, again, it totally depends upon your drafting skill. If you draft a really good legal notice, then you can charge more. And if you are a beginner or a average drafter, then you can charge as per your convenience. And nowhere it is mentioned that how much amount is to be charged by the lawyer. Next is what to do when you receive a legal notice. First, you will be reading carefully. Carefully read the notice. Understand each and every points word by word. Please make sure to explain your client at what the legal notice is all about, what it is stating, and in case of non-compliance of that particular legal notice, what consequences your client will face. Contacting an advocate, of course, you all are going to be lawyers, so you need not be contacting an advocate, but it is always better and advisable to contact with your friends or to have a discussion on that particular notice among your friends circle. They will add some new points into it. Briefing the advocate, again, it is not applicable to you all because you all are going to be a lawyer. The person who does not knows the law or who is the layman should brief all the problems. And if you are an advocate, a client comes to you, then you will be asking everything about the problem from your client. You will get a better insight just by asking about the problems or just by doing a legal counseling or legal session for your client. Sending a reply, of course, a reply of the legal notice is to be sent and it should be well drafted. Mm, Conclusion is simply that it is a formal communication between two parties, and Legal notice is a outside court settlement. It saves times and cost. And now I will be opening up for the Q&A session. If you are having any doubt related to legal notice, please either type in the chat box, or you can open your mic one by one and can directly interact with me. Uh, One guest user has asked, "Sir, please explain about the company as well." What company you are asking, dear? I did not get your question clearly. Mm, Amit, is it registered notice under Section 80 CPC? If I remember well, then under Section 80 of CPC, legal notice is served to the government officers. Suppose you have to write a legal notice to the honorable PM of this country, then you will not write directly to the honorable PM of your country. Uh, you cannot directly send a legal notice to honorable Narendra Modi. You can write that to Mr. Narendra Modi or whatsoever and his proper address, but after that you will write through home so through minister or office. And if you do not mm, append to to write to government office through better you so just give a code going to code to save people this legal notice given to give
So you're not audible.
is my voice clear?
Yes, sir.
Okay, please type your questions in the chat box. To draft a legal notice, should we ourselves be a registered advocate? See, it is not necessary to be a registered advocate to draft a legal notice. You can draft a legal notice now as well. If you are a student, you can draft a legal notice. It is nowhere written that a legal notice should be drafted by advocate or any particular person. Everyone can draft a legal notice, but it is always advisable either to have a knowledge of law, or if you don't have a knowledge of law, like for the layman's person, you can contact your advocate. Sir, can we as students send a legal notice or should we be registered as an advocate? See, it is nowhere mentioned that you should be a registered advocate under the Bar Council of India. I am a CS professional. I have not at all registered in the Bar Council of India yet. So, and I have written so many legal notices. So you can write legal notice as well, being a student or being in any profession. It does not really matter. So it can be considered as a primary evidence. See, notice is not an evidence, but in court of law, the court will establish, you can establish your case by stating that I have informed about the concerned person once before coming to this court. For example, if you have been served with a legal notice, and you duly reply to that legal notice. This is one scenario, and in another scenario, you did not reply to the legal notice. You just skip the legal notice. So after suit, what court will presume? If you have not replied to a legal notice, court will presume that this particular person is a culprit, because a true person mm, will reply and will face the challenge. But the culprit will not reply, he will avoid all the notice and court's summon. So this is a presumption of court. Court is also run by human beings, so human being presumes just by the mere facts of the case. Sir, can we students okay? Sir, some MNC companies also serves a so-cause notice to their employee. What is a so-cause notice? See, I will explain a bit about so-cause notice. So-cause notice is something like you explain your reason. Okay, whose mic is open? Okay, so-cause notice is like you will explain your reason. The MNC will be asking you, or MNC wants you the reason. Suppose Mr. A is the MNC company and Mr. B is the employee. Mr. B has breached the contract and left his job in the meanwhile. Then MNC or the manager of the company or whatsoever employer will issue a so-cause notice that to Mr. B, asking him that why Mr. B has left that particular position or breached the contract. Means so-cause notice why no suits shall be initiated against you. What is your reason why you have left, and why we should not take any actions against you. This is a so-cause notice. Suppose one draft notice find something inedible. Vismita, your question is not clear. You can open your mic and interact with me. So can we deliver legal notice directly to person X? Yes, of course, you can deliver legal notice to directly to a person. Even in case of someone, you can specifically deliver a summon to the opposite party. Even the courts also accepts this because it saves time and of course the cost of delivery of summon. If you are having any doubt, please type as quickly as possible. Do we have to write legal notice in this internship? Yes, in this internship, you have to simply draft a legal notice, and the scenario for drafting a legal notice will be provided in the group. You will be drafting a legal notice of an ongoing case in the High Court. Uh, the case is ongoing. You will be drafting notice, and the best notice or some points from the different notice will be selected, and we will serve him the legal notice as well. So it would be the real case. Maximum time limit given to a person for a notice. See, there is nowhere in the law prescribed the maximum time limit or the minimum time limit. Time limit depends. Go with the reasonable. A reasonable time limit should be given to the opposite party. And what is reasonable? It is the question of facts. It depends upon circumstances of the case. Suppose you are a person from Delhi drafting a legal notice to a person sitting in Andaman and Nicobar, then of course you will have to give him like at least a month, because notice will reach from Delhi to Andaman, and from Andaman to Delhi it would take a month. So it depends upon the circumstances, and whether it is reasonable or not, it is all up to the court to decide what is reasonable and what is not reasonable. It is nowhere mentioned in the law. Suppose we find a lizard in the soup. Should we show proof of it? Fine to just send a legal notice. See, lizard in the soup. You can just click a snap, click a picture of that particular lizard, and can sue the person, sue the concerned authority, or can send a legal notice to the concerned authority. I remember a case where a person has found something like insects in the beer bottle, and he directly sued the beer company. But the company had taken defense that since we are the producer, some middleman might have added that particular insects in the beer just to defame the name of the company. But the court stated that it is not so. If you find found lizard in the beer bottle, just have a picture, just click snap, write a legal notice to that particular person demanding your compensation, and if that particular authority fails to do so, then you can file suit against them, and company is not at all pardoned from this. Yes, Donag versus Stevenson case law you can find in Loft dot, I think, most probably Loft dot. If the person who got the legal notice to pay X amount is not able to pay the but agrees to pay a lesser amount. See, if you have issued a legal notice to a person demanding him rupees 50 lakh, but that particular person agrees to pay 30 lakh, then it is all up to you to whether accept that particular 30 lakh payment, or to file a suit against that particular person demanding for 50 lakh. It all depends upon your negotiation skill, your negotiator, or your satisfaction. If you are not satisfied with the money, then you can file a suit against that particular person. But if you are satisfied, then just keep it, no issue. It is like a counter offer. See, legal notice is not like playing with legal notice. Just by sending legal notice to that person will reply you, then you will again file a reply. This is not a play game. You can simply have a call and have a conversation with that particular person, and you can negotiate on it. Legal notice is not like that you will be sending replying each of legal notice and negotiating it. You can negotiate it on call as well, and finally you can draft a legal notice and settle that particular dispute. I think everything is clear to you. Can any type of oral conversation be construed as legal notice? See, Rebecca, in civil suits, if you go for suit in company, or money suit, or recovery of money, or defective in the goods, these suits are called civil suits. So in case of civil suits, courts do not accept oral submission or oral arguments. Courts only accept written submission, written argument, affidavits, and all. So in civil suits, it is mandatory to draft, to write. Okay, oral conversation till date does not construed as legal notice. It is simply construed as reminder. I think we should end this session here. Is it necessary to file a notice before filing a suit? It is not at all necessary. It all depends upon you whether you want to remind that particular person, whether you want to settle the dispute outside the court or not. If you want to settle the dispute, you can file a legal notice. If you do not want to settle the dispute, if you want to go for a suit, then of course you can go for a suit. It is not recommended to file a legal notice before going to a suit, but it is advisable to do so in civil suits because civil suits takes a long time to settle. For the criminal offense, can anyone send a legal notice? Mm, so in criminal offense, I don't find sending of any legal notice, because in criminal offense, mostly courts send the summons and not the legal notice, and there is a difference between summon and notice. So because criminal offense is against the state, so state will serve the notice. You should not be going and serving notice in the criminal offense. you can directly file a suit in a case in criminal offense. I hope that everything is clear, and I believe that you would you draft legal if you have been given a scenario. Okay, so let's end this session here. You can comment how do you find this session, whether it was useful or not, and you may exit now. Thank you so much, everyone.